Elon Musk was hit with a $3.2 million fine, and everyone expected him to simply pay up and move on. But what happened in that courtroom left even the judge astounded. It was meant to be a routine morning in courtroom 7B at the federal courthouse in Fresno, California. The sound of rain tapping against the windows filled the air. The clerk shuffled through paperwork. Reporters adjusted their cameras and sipped their coffee from paper cups, looking bored. Then the door opened and in walked Elon Musk. No bodyguards, no legal team, just a gray suit, a dark tie, and a neutral expression. People looked up, mildly curious but not surprised. Musk had been summoned for allegedly violating court protocol in a previous case involving one of his companies. The court's complaint accused him of disclosing sealed details during a press event weeks earlier. It seemed like a straightforward breach of conduct. Judge Deirdre Colton presided over the case. She was known for her sharp, no-nonsense demeanor, especially when dealing with high-profile figures. She glanced up from her notes, met Musk's gaze briefly, then returned to her paperwork. "Elon Musk," she began in a calm but firm tone. "You have been found in violation of federal court orders concerning sealed testimony. The fine is $3.2 million due within 14 days. There were no gasps, no dramatic pauses. This was Elon Musk. After all, a billionaire CEO and media magnate. A few million wouldn't faze him. But the way he stood there, hands loosely folded, no reaction, created a subtle shift in the atmosphere. Judge Colton leaned forward, perhaps expecting some kind of response. "Do you understand the terms of the judgment?" she asked. "I do," Musk replied flatly. "But I'd like to address the court now." Heads turned. Some reporters straightened up. He had come without a lawyer and now was asking to speak directly in front of a federal judge. Judge Colton raised an eyebrow. "Mr. Musk, I recommend you have legal representation before continuing." "With respect, Your Honor," he responded, "I believe it's more fitting that I handle this personally." Colton nodded slowly. "Proceed." And that's when things started to take an unexpected turn. Musk reached into his jacket pocket and pulled out a single sheet of paper. It was neatly folded, no binder, no folder. He placed it on the table in front of him. "I'm not disputing what I said publicly," he began, "but I am disputing whether the gag order applied in this situation. That got attention, a legal gray area. The order referenced in the contempt filing is tied to Section 35B of the protective hearing order issued on March 11th. Musk continued. However, subsection 35B3 allows for public safety exceptions under federal fair use laws, especially when the disclosed information involves risks that could affect stockholders. Judge Colton blinked once and reporters started typing. "I only referenced one aspect of a manufacturing process that could have been dangerous for consumer safety if misunderstood. I didn't name anyone, didn't cite protected documents, just shared my own concerns based on what I observed firsthand," he explained. The room fell silent. A paralegal leaned over to whisper something to a colleague. Even the bailiff, who had been watching the door, seemed slightly confused. Judge Colton raised an eyebrow. "Are you suggesting that you are protected by federal whistleblower statutes?" "I'm saying," Musk replied calmly, "that the fine being imposed on me may contradict a precedent set in Stansfield Verde U.S. Tech Holdings, 9th Circuit 2004, where the court ruled that executive disclosures for the public good cannot be penalized under seal protection if the statements fall outside the gag order's original scope. There was a specific case, a ruling, a dated precedent. It wasn't flashy. It wasn't for show. It was precise, calm, strategic. And at that moment, everyone in the room knew it. But Judge Colton wasn't fond of surprises in her courtroom. And Musk had just flipped the script. She didn't respond immediately. Instead, she leaned back, fingers steepled together, staring at the man who had just quoted circuit law like he belonged at the counsel's table. For a long moment, the only sounds were the hum of overhead lights and the occasional tap of a reporter's laptop keys. "Elon," she finally said, dropping the formalities for the first time. "You realize that citing precedent doesn't guarantee exemption. This isn't a theoretical discussion. This is a federal penalty." Musk didn't flinch. I'm aware, he said. But if the penalty contradicts its own framework? It wasn't what he said. It was how he said it. Calm, measured, like he had rehearsed those words countless times. Not in front of a mirror, but from a place of certainty. Not arrogance, not charm, just clarity. The atmosphere in the courtroom shifted. The judge was no longer addressing a man accused of misconduct. She was now in a conversation with someone who might actually know what he was talking about. A reporter in the back whispered, "Why didn't he bring his legal team?" Another whispered back, "He must have wanted to make this personal." And maybe he had. By now it was personal. "Mr. Musk," Colton said, returning to a formal tone, "are you requesting a formal motion to dismiss the fine?" "No, Your Honor," Musk replied. "I'm requesting a reassessment based on Statute 1287F Provision 4. I believe the fine exceeds what that statute allows in cases where sealed disclosures are nonspecific and intended to address imminent shareholder risks." He paused. "I can provide examples of rulings that support that logic." Judge Colton exhaled slowly. "You're serious?" "I wouldn't be standing here if I weren't," Musk answered. There was something subtly unsettling about it, not disrespectful, but unusual. It felt like watching someone dismantle an argument in a game they weren't supposed to understand, let alone win. She motioned for the clerk. "Get me the transcript from the March 11th hearing and the full ruling from Stansfield versus U.S. Tech. Holdings on my desk this afternoon." The clerk stood and hurried out of the room, leaving a tense silence behind. "Elon," Colton said, this time with a tone that almost seemed parental, "you do realize what's at stake here. You're not just questioning a fine. You're challenging the very limits of courtroom discretion." Musk nodded. "Yes, but respectfully, Your Honor, if a court can impose unlimited fines for statements that fall outside the language of a gag order, then where does that discretion end?" A man from the SEC sitting behind Musk quickly scribbled something in a legal pad. Another attorney from a rival firm subtly pulled out his phone, typing under the table. This was no longer a simple contempt case. It had become something else. A moment. A turning point. The kind of moment law students would study years later when a defendant didn't fight back with theatrics, but with logic. Musk picked up a printed copy of the March 11th order, something he had clearly brought with him, and handed it to the judge. "Pages 3 and 4, he said. "Look at the third paragraph for the exception clause." Colton didn't even look up as she took the paper, scanning it quickly, her lips pressing together. "This court has discretion," she muttered. "But even discretion," Musk replied, "has limits." No one spoke. Then, slowly, Colton looked up, not with anger or annoyance, but with something approaching realization. She didn't dismiss the fine. Not yet. But something in her expression suggested the certainty behind it had begun to crack. If Musk had cracked a hole in the dam, the real test would come soon. How far would the water go? When the courtroom reconvened after lunch, word had spread. Local journalists had already tweeted fragments of Musk's self-representation. National outlets were gathered outside 7B, filled with camera crews and legal analysts. People who had never cared about procedural statutes were suddenly asking, can Musk actually win this? Inside, the atmosphere was quieter, but still charged. It felt like everyone was holding their breath, waiting for a mistake, a stumble, something to prove Musk was just another tech mogul pretending to understand the law. But he didn't stumble. Musk sat at the same desk, hands folded, his expression unreadable. He didn't check his phone, didn't glance around. He simply waited. Judge Colton returned, holding a yellow legal pad filled with notes. She didn't sit down right away. "I reviewed Stansfield twice," she said. "And I went over subsection 35B of the gag order. You were right about the exception clause." A soft murmur ran through the gallery as she held up the copy Musk had given her. "But this exception only applies when the disclosure addresses direct threats to consumer safety, not just speculation. Your statement suggested a potential risk, but not a confirmed one." Musk nodded. "That's fair." "But the wording doesn't require confirmation," Musk countered. "It requires good faith. That's the legal standard, and the court can't punish good faith disclosures even if the concern turns out to be exaggerated or non-lethal. She stared at him. You're walking a tightrope. I've walked narrower, he replied. A few chuckles came from the back of the room. Even Judge Colton allowed herself a faint smile. But just for a second. I also reviewed your timeline, she continued, returning to her bench. You made your comments 2 hours after the hearing, which suggests you may have spoken before receiving the full written order. Did you have access to the language? She asked. Musk shook his head. No, I had access, but the oral summary of the hearing was unclear. The full transcript came via email 6 hours later, and by then the press had already picked up my statement. The courtroom fell silent again. Judge Colton leaned forward. So you're saying you accept responsibility for the timing but not the intent? Exactly, Musk said. I was trying to alert shareholders about a potential risk. It wasn't about headlines or ego. The data I referenced was from our internal audits. That makes it mine. A young lawyer in the back whispered to her colleague, He's unraveling every detail. Her colleague whispered back, Yeah, and somehow it's holding. Colton flipped through her notes again and then looked up. You know, she said, this court doesn't typically get corrected by civilians. Musk replied without hesitation. Then maybe it's time for that habit to be reviewed. It was bold, direct, but not smug. The tone wasn't that of someone trying to win an argument. It was the tone of someone who believed the truth mattered more than who said it. For a moment, the courtroom felt still, not frozen, just still, like everyone had been knocked off balance but didn't want to admit it. The judge spoke again, slower this time. You're forcing this court to apply precedent it hasn't considered in over a decade. I'm just asking the court to apply its own rules, Musk replied. Colton tapped her pen on the desk twice. I'll take this under advisement. We will reconvene in 24 hours for a final ruling. Until then, no further statements to the media. Understood, Musk said. She stood, grabbed her files, and walked out without saying another word. Musk sat for a moment longer, then calmly gathered his papers and left the room, not like a man who had won or lost, but like someone who had simply said what needed to be said. But as he stepped into the hallway and saw the wall of reporters waiting, it was clear. This was no longer just a courtroom moment. It was about to become a national conversation. A brief pause. Soft murmurs filled the room. Judge Colton turned her gaze toward Musk. Your interpretation of the exception clause in relation to your reference to Stansfield was correct. While this court rarely overturns its penalties, the fine will be reduced from $3.2 million to a nominal $25,000, recognizing both the violation and the legal reasoning behind it. No applause followed, but a wave of surprise swept through the crowd. Elon Musk didn't smile. He didn't nod. He simply responded with a quiet, "Thank you, Your Honor." But the judge wasn't finished. Let me be clear. This decision is not being made because of your wealth or public status. You earned this reconsideration through your preparation, respectfulness, and the clarity of your argument. It's not something we see often, but it does matter. A woman sitting behind, Musk leaned toward her husband and whispered, I expected him to be arrogant, but he's not. He's just different. With a final closing motion, the judge put her binder away. Court is adjourned. As people rose to leave, reporters rushed for the door, eager to file their stories. Musk stayed seated for a moment longer, watching the judge exit before standing up, walking past the now silent gallery, and leaving through the same door he had entered. Outside the courtroom, however, the world was already spinning its own narrative. Headlines began to appear within minutes. Elon Musk challenges court, gets fine reduced. Judge revises ruling after Musk's self-defense shakes the courtroom. One man, no lawyers, and a whole lot of legal precedent debate soon erupted. Was this a brilliant legal maneuver, or was it just another example of the rich playing by different rules? Did it show that powerful figures could manipulate the system, or that truth could still sway even the most inflexible institutions? Some speculated that Musk had orchestrated the entire scene, staging a spectacle to gain public sympathy. Others believed the opposite, that he had expected to lose but simply spoke because it felt like the right thing to do. One thing was undeniable. Everyone had seen it firsthand, not in a headline or a tweet, but in real time. A man stood in a courtroom, confronted the system trying to penalize him, and managed to change its course, not with money or force, but with words. But the media noise was only the beginning. The real storm was just starting. The public had questions and the system wasn't ready for them. That same afternoon, Judge Deirdre Colton sat in her chambers, a cold cup of coffee by her side, staring at a legal pad filled with notes she hadn't expected to make. Her clerk had stepped out, leaving her with a phone buzzing with missed calls, reporters and law school friends, some she hadn't spoken to in years. She looked at the door for a long moment before returning to the notepad. 5 words were underlined. He wasn't wrong. Not entirely. Colton was no stranger to controversy. In her 26 years on the bench, she had dealt with racketeering, class actions against major pharmaceutical companies, and civil rights cases that drew national attention. But she had never encountered someone like Musk, someone who entered her courtroom, spoke plainly, and dismantled a multi-million-dollar fine with little more than legal footnotes and a few carefully placed references. It wasn't the reduction in the fine that caught her off guard. It was the realization that Musk had forced her to acknowledge that the court might have overstepped its bounds. She pulled up the ruling once more. Section 35B, Exception Clause, Whistleblower Intent. There it was, clear and unequivocal, buried on page 4, exactly where Musk had said it would be. She jotted a note in the margin. We missed this. Why? A knock at the door interrupted her thoughts. Her clerk returned, holding a small folder. Judge, he said, the Office of Legal Oversight wants a brief on the Musk case by Friday, and Channel 12 is asking for a statement. She dismissed the second part with a wave. No press. He hesitated. There's more. Law students at UC Davis are circulating the transcript. Professors are assigning it as a legal ethics case study. It's turning into a big deal. She raised an eyebrow. A big deal? He nodded carefully. They're calling it the Fresno defense, like when a defendant turns the courtroom around using its own rules against it. Colton almost laughed but held it in. She closed the door with a soft click. Fine, she muttered, as it clicked shut. She stared at her screen. The raw transcript from yesterday's session was open, with Musk's words, calm, measured, and strategically placed, jumping out as though they were highlighted in bold. She scrolled through it again, pausing on a specific section. If a court can impose unlimited fines for statements that aren't protected by the specific wording of the gag order, where do we draw the line? What are the limits of that power? That question lingered, for it was one with no easy answers, and now every judge in the country would be thinking about it. Meanwhile, across town, Musk sat quietly at a small cafe off Ashland Avenue, gazing out the window while his assistant spoke on the phone nearby. There were no celebrations, no interviews. He was simply deep in thought. A woman in her late 50s approached his table holding a to-go cup. "Excuse me, sir," she said gently. "I don't agree with everything you said in there, but I watched it online and it mattered. The way you carried yourself, it really mattered." He looked up, taken aback. "Taken. Thank you," he replied simply. She smiled, gave a nod, and walked away. There was no applause. No fanfare. Just a small, quiet moment. Back at the courthouse, Colton reopened a private memo from the district's legal review board. The final paragraph was clear. While the reduction of the fine was unexpected, it reflects the court's capacity to recognize its limitations when confronted with sound legal arguments. This is not a sign of weakness but a reinforcement of judicial integrity. She read that sentence for a while, before letting out a breath she hadn't realized she was holding. But if a single courtroom could be shaken in this way, what might happen when the broader legal system took notice? By the next morning, it wasn't just legal experts or reporters buzzing about the case. Ordinary people were talking about it. Uber drivers discussed it between rides. Barbershops in Fresno and Bakersfield exchanged terms like gag order and whistleblower clauses as though recapping a sports game on late-night AM radio. A caller on one show said, "I don't even like the guy, but what he did in that courtroom, that was something else." Cable news shows scrambled to book constitutional experts. Clips of Musk's courtroom appearance began trending, not because of any theatrics, but because of the opposite. No outbursts, no grand gestures, just a man calmly dismantling a fine he believed was unjust. One national morning show even ran a side-by-side comparison of Musk's transcript and Colton's revised ruling. A former federal prosecutor appeared on live television and shook his head. He played the long game. He anticipated the counter-arguments before they even came up. The term Fresno defense quickly appeared in opinion columns. Editorial boards began asking tough questions. How often do courts issue fines without fully considering legal exceptions? How many people simply pay because they don't have the resources or the courage to push back? Musk had become more than just a billionaire. He had become a symbol of something people didn't even realize they needed. A reminder that the system could still be challenged, and sometimes bent if you understood it well enough. But not everyone saw it that way. At the Department of Justice, an internal memo warned federal judges about the potential consequences of this case. While Musk's approach was unorthodox, if left unchallenged, his arguments could encourage more courtroom disruptions by high-profile individuals choosing to represent themselves. One columnist in a San Francisco newspaper called it dangerous. "We cannot allow courtroom gamesmanship to be glamorized, even when the person behind it has 12 zeros in their net worth. The law isn't a game." Others, however, countered. A retired judge from Sacramento wrote an op-ed defending Musk's actions. Elon Musk didn't challenge the law. He used it. He reminded both the public and the judiciary that no system is too powerful to be questioned. That's not rebellion. It's democracy functioning as it should. Even some skeptics couldn't ignore what had happened. At a law school in downtown Los Angeles, Professor Joanna Menendez began her civil procedure class by putting Musk's transcript on the board. "Like him or not," she said to her students, "this is how you speak when you've read every line twice. This is how you walk into a room where the odds are stacked and say, 'Here's what you missed.'" Back in Fresno, Musk remained quiet. No press tours, no public statements. He returned to his work business as usual, but his staff began noticing a shift. There were more cautious glances, more careful tones when they greeted him. One engineer asked, "Were you nervous in there?" Musk responded, "Yes." "Did it show?" "I don't think it mattered." The truth was, his fear had never stopped him from standing up and speaking. He hadn't bypassed the court. He hadn't won by exploiting a loophole. He'd simply followed the rules and read them more carefully than anyone had expected. That was the lasting impact. Not the fine, not the cameras, but the idea that knowing the rules could be just as powerful as breaking them. While Musk moved on, the system he had challenged couldn't shake the moment. The ripple was only beginning. Weeks later, long after the headlines had faded, the story still lingered, quietly, persistently. In offices and courtrooms across the nation, judges referenced the case in passing. Law firms updated training materials. Professors still incorporated Musk's arguments into PowerPoint slides titled, "When the Defendant Fights Back." But the true impact was not within institutions, it was within the people. Marcus Albright, a 34-year-old mechanic from Flagstaff, had never followed a courtroom drama before, but he stumbled upon a clip from the hearing online. A 6-minute video of Musk speaking with nothing but a piece of paper before him. No arrogance, no shouting. Just a man making a point no one could ignore. Marcus didn't care much for billionaires, but he watched the clip twice and printed it out, bringing it to work. "Why print it?" his coworker asked. "Because a man like that can walk into a courtroom and tell the truth without hiding behind a team of lawyers. Maybe I can speak up at my next union meeting without second-guessing every word." In Sacramento, Barbara Levis, a 62-year-old retiree, filed a motion to contest an old housing code fine she believed had been mishandled. She referenced the Musk case to the judge. The court clerk, to her surprise, was familiar with it. Though her appeal wasn't overturned, it was reviewed again. She got a partial refund. The message wasn't that Musk had outsmarted the system. It was that the system, when confronted with reason and calm defiance, could pause, reassess, and admit when it had made a mistake. That moment in the courtroom stuck with people. It wasn't about admiration or personal gain. It was structural. The facts were sound, the argument reasonable, and when the judge saw that, she corrected course. But outside the courtroom, it felt different. It felt like something more. A moment where accountability no longer ran in just one direction. In a podcast weeks later, the host asked bluntly, "Was this about power, or was it about precision?" The guest, a legal analyst, paused before responding. "Precision is power. It's just quieter. That's what made this so effective." Musk didn't raise his voice, he raised the bar. And maybe that's the lesson. In a world where noise often drowns out truth, Musk's case reminded us that sometimes the quietest words hold the greatest weight. Because when you stand firm on the truth and know exactly why you're right, no courtroom is too big to hear you.